So let's turn to Lesson 26, which examines the question, how does American federalism work? Now, obviously, unlike unitary systems in which all levels of government are extensions of the national government, we have two levels of government, national and state, and the relationship between them and their respective powers is not always clear. So let's begin by asking, what is the constitutional status of state governments? And more specifically, let's start with what was the status of state governments under the Articles of Confederation?
This is a very important question for the purpose of history and our own time. Under the Articles of Confederation, states were considered to be sovereign, and therefore states, jealous of their powers, delegated authority to the Congress on a very sparing basis. And so at the time of the framing of the Constitution, the framers had to deal with those state jealousies, a concern not to grant too much power to a very remote national government over which states could exercise little authority, but mindful of the fact that the Articles of Confederation as a constitution proved to be disastrous. And so inside the Constitutional Convention, the framers decided to replace state sovereignty with the concept of popular sovereignty, recognizing that all constitutional authority, all political authority flows from the people, not the states. That meant that in the convention now, the framers, with the adoption of the Supremacy Clause in Article 6, would make the federal government or the national government superior to states. States then under Article 6 would be bound to carry out the laws passed by Congress, and that would bind judges. So very quickly, the framers of the Constitution, recognizing the need for a Supremacy Clause, acted to move to restrain states and to give them a status that was far more limited than the status they had under the Articles of Confederation.
How then did the Constitution change the status and relationship of state governments to the national government? For example, what are the implications of the 9th and 10th Amendment?
Taking into account the 10th Amendment, first of all, the Supreme Court has said the 10th Amendment states but a truism. Those powers not granted by the Constitution to the national government nor prohibited by it are left to the states, reserved to the states, leading people to wonder, well, what exactly are state powers? And that's been the subject of great dispute across 2 centuries, particularly as the flow of power from the states to the national government has left states in a more weakened position than when they started at the time of the founding. Also, the question led Justice Frankfurter in a 1940s opinion to quip, well, only a state can build a state house. Didn't necessarily please those who wanted broader state powers, but it reflected the quandary. What are state powers? People recognize that under the 10th Amendment, that the reserved powers certainly include a broad array of what we call police powers, broad authority vested in each state legislature to pass laws governing the health, morals, welfare, and safety of the people. And of course, states have authority to legislate in other areas as well. But the fact of the matter is, over time, state powers have been diminished by virtue of congressional action and Supreme Court decisions. The 9th Amendment, equally as controversial, has been at the heart of some of our great disputes, because the 9th Amendment provides that the enumeration in this Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people, which raises the question immediately, what are those other rights retained by the people? Now, when James Madison introduced the Bill of Rights in the very first Congress, he introduced the 9th Amendment as protection against the possibility that his list of enumerated rights and liberties might not include all the rights that he envisioned as being important, and he didn't want to omit any of those important rights. And ironically, on the day in June of 1789 when he introduced the Bill of Rights, he forgot to mention a pretty important freedom, namely freedom of speech. He was quickly aided and comforted by his fellow Virginian, George Mason, who said he was sure Mr. Madison had intended to include free speech, but he had forgotten. So that proved Madison's point, that in fact the convention might in fact forget to mention an important right or two, hence the meaning of the Ninth Amendment. But the reason why the Ninth Amendment becomes so controversial over time then is because the question is, how will the court decide in the course of decisions on what those other rights are retained by the people? It's clear that the American people have implied rights, but the question is, what are those rights?
You mentioned police powers and reserve powers. Can you amplify just a little bit about what those terms mean?
The police powers of a state harken all the way back to Roman law, and the government needs to have authority to pass laws to govern these basic areas of their citizens' interests and lives. The state governments in our country have long wielded very important powers in the areas of welfare and in the areas of education and in the area of protecting the interest and the personhood and the property of individuals. And so states passing laws in the name of the police powers, for example, have required school children to be vaccinated before they go to school. The state, in the exercise of its police power, has enacted compulsory education requirements. These are essentially powers carried out by state legislatures that can change at any point in time on the views and the values of those in the legislature. Gambling is another good example. At various times, gambling was considered to be immoral and banned. Other times, it was a boon to economic commerce. On another occasion, a reflection of the will of the people to permit it if people want to participate. So the police powers are very broad and aiming to cover those very basic areas of American life.
And reserve powers?
Reserve powers would fall into the category of saying that the states have authority by virtue of the 10th Amendment to pass laws that pursue its own interest in areas such as criminal law or education or tax policy.
What powers does the Constitution prohibit states from exercising?
You find prohibitions in Article 1, Section 9, where in fact the states are barred, for example, from passing laws that reflect an ex post facto law or a bill of attainder, or in effect establishing a currency or granting titles of nobility. The states then are barred from doing some very specific acts. Those are among the principal examples.
Can you talk for a moment about the tensions that persist between matters dealt with by the state and national governments?
Over the course of our history, and particularly in the last half century or so, we've seen great tension governing the area of civil rights. Other examples would include health practices, healthcare laws, such as the Affordable Health Care Act passed by the recent Congress under the presidency of Barack Obama. We see tension in the area of environmental legislation as well. Education has been the subject of ongoing controversy as states sometimes express regret that the federal government has dared to legislate in the area of education on the assumption that education has been more of a local matter or a state power.
Which leads me to ask about the significance of the Supremacy Clause.
The Supremacy Clause in many ways constitutes the real glue of our federal system. Under the Articles of Confederation, because states were considered to be sovereign, the Congress was unable to enact legislation to govern the country as a whole because it had to rely on states to adhere to the laws and enforce them, and states were often reluctant or unwilling to do so. Congress would negotiate treaties with foreign nations, and again, the states would thwart those efforts. And so one of the very most important steps that the framers of the Constitution took in writing the Constitution was the inclusion of a Supremacy Clause, which makes the laws of the national government and treaties of the nation the supreme law of the land. And the Supreme Court said very early in 19th century cases that the Union would come to an end if states were not bound to carry out the national laws.